Delegated legislation. Delegated or secondary legislation is usually concerned with detailed changes to the law made under powers from an existing Act of Parliament. Statutory instruments form the majority of delegated legislation, but it can also include rules or codes of practice. There are three basic types of statutory instruments: regulations, rules, and orders. The first question that arises from this discussion is, why do we need delegated legislation in the first place? Why can't we use primary legislations to run the government? In which area do you think the primary legislation lacks application? The answer is that the delegated legislation allows the government to make changes to a law without needing to push through a completely new Act of Parliament. This way, the government can implement policies that may have been stalled because of the limitations of the primary act that were not visible when the act was enacted. The original act, which is also known as primary legislation, would have provisions that allow for future delegated legislation to alter the law to differing degrees. What kind of changes do you think the delegated legislation can facilitate the operations of the government? These changes have a broad range. They can be technical, like altering the level of a fine, to procedural, like to add greater details to the act. Do you think it's a good idea to write the Act of Parliament in significant details, or do you think the acts should be broad and general? Often, an act contains only general framework for its purpose, and more complex content is added through delegated legislation. Statutory instruments, SIs, are a type of delegated legislation. Approximately 3,000 SIs are issued each year, making up the bulk of delegated legislation. About 2/3 of SIs are not actively considered before Parliament and simply become law on a specified date in the future. SIs are normally drafted by the legal office of the relevant government department. Consultations often take place with interested bodies and parties. Let's look at the parliamentary procedure on statutory instruments, or SIs. The first step is to determine if an SI is subject to parliamentary procedure. The parent act is used to determine this. Some SIs are not presented before Parliament and as such are not subject to any parliamentary procedure and simply become law on the date stated in them. There is some scrutiny because these SIs are scrutinized by the Joint Committee on Statutory Instruments. Such instruments are, in general, not controversial. Commencement orders fall into this category. So do orders of council. Most SIs are subject to parliamentary control. The type of parliamentary control will be designated in the Parent Act. An instrument is presented before Parliament either in draft form or after the instrument has been made. It is important to note here that in the case of instruments dealing with financial matters, they are only presented in front of the House of Commons. Most SIs are either subject to a negative resolution procedure or subject to affirmative resolution procedure. In case of negative procedure, further details are presented in the Statutory Instruments Act 1946. We will briefly look at both of these proceedings. In the case of negative procedure, the SIs become law on the date stated on them, but will be annulled if either house passes a motion calling for their annulment within a certain time. This time period is usually 40 days, including the day on which it was presented. The days that are excluded from the time period are the days when the Parliament is dissolved or prorogued, or when both houses are adjourned for more than 4 days. In the House of Commons, any member may put down a motion to annul an SI subject to the negative procedure. In practice, such motions are now generally put down as early day motions, or EDMs, which are motions for which no time has been fixed. If a motion is put down by the official opposition, the SI mentioned in the motion is usually debated. An annulment motion put down by a backbencher is unlikely to lead to a debate, unless there is a large number of signatories to the early day motion. In the House of Lords, motion can be tabled by an individual member and are usually debated, although rarely put to the vote. Statutory instruments subject to the affirmative procedure are less common than those subject to negative procedure. The affirmative procedure provides more stringent parliamentary control, since the instrument must receive Parliament's approval before it can come into force or to remain in force. Most SIs subject to the affirmative procedures are laid in the form of a draft instrument for approval by both houses. The responsibility lies with the minister, having laid the instrument to move the motion from approval within a timely manner. Some instruments are laid after making and will come into effect immediately, but require subsequent approval within a statutory period, usually 28 days or occasionally 40 days, to remain in force. This again excludes periods as mentioned before.